process as I'm playing Ryle or as I'm directing. There's just time.
From the outset, Judge Ramirez made it clear that this was not a tabloid drama, but a serious legal matter. During an early hearing in March 2023, she issued a temporary restraining order, TRO, prohibiting Lively from launching or promoting any aspect of Preserve Collective until the court could determine the rightful ownership of the disputed assets. The order was explicit: no social media posts, no product announcements, no interviews referencing the brand, and certainly no commercial activity tied to the contested intellectual property. Violation of the TRO, Judge Ramirez warned sternly, would be treated as contempt of court, a punishable offense that could include fines or even jail time. For several months, Lively appeared to comply. Her Instagram, normally a vibrant mix of family photos, fashion moments, and subtle brand endorsements, went conspicuously silent on anything related to Preserve. Industry insiders speculated that the actress had shelved the project indefinitely. But behind the scenes, according to prosecutors and Ellison's legal team, Lively was orchestrating a covert campaign to undermine her former partner and reclaim control of the narrative. What emerged during the discovery phase of the trial was a meticulously documented trail of digital communications that painted a troubling picture. Emails, text messages, and encrypted signal chats revealed that Lively had enlisted a network of associates, including a publicist, a social media manager, and even a close friend who ran a small e-commerce site, to circumvent the court's restrictions. The scheme, as outlined in court filings, involved the creation of a ghost brand called the Hearth and Vine, which bore striking similarities to Preserve Collective in name, aesthetic, and mission. Products developed under this alias were quietly listed on third-party platforms, and promotional content was seeded through influencer networks with no direct link to Lively. Legal experts weighed in with near-unanimous agreement that Judge Ramirez's ruling was justified. This wasn't about punishing a celebrity, said constitutional law professor Dr. Helen Cho in an interview with NPR. It was about upholding the integrity of the judicial process. If a federal court order can be ignored by someone with enough money and influence, then the rule of law means nothing. The fallout extended beyond the courtroom. Lively's production company, B for Effort, co-founded with husband Ryan Reynolds, reportedly put several projects on hold as her legal team scrambled to contain the damage. Endorsement deals with major brands, including L'Oreal and Gucci, were quietly reviewed, though none were publicly terminated. Reynolds, who has cultivated a reputation for self-deprecating humor and savvy business acumen, remained publicly silent on the matter, a notable departure from his usual active social media presence. Meanwhile, Mara Ellison emerged as an unlikely symbol of the little guy standing up to Hollywood power. In a rare interview with the New York Times, she described the emotional toll of the ordeal. "I didn't go into this wanting to destroy Blake Lively," Ellison said. "I just wanted credit for the work my team and I poured our hearts into. When she tried to erase us and then lie about it in court, that's when it became about more than money. It became about truth." As the dust settled, the case sparked broader conversations about intellectual property in the digital age, the ethics of celebrity entrepreneurship, and the dangers of conflating personal brand with legal accountability. In an era where influencers and actors routinely launch lifestyle empires, from Goop to Honest Company, the Lively-Ellison dispute served as a cautionary tale about the fine line between inspiration and appropriation, and the consequences of believing one is untouchable. Ironically, the very qualities that once defined Blake Lively's public persona, her meticulous Lively's attorney, high-profile litigator Miranda Hayes, attempted to frame the actions as misguided enthusiasm rather than willful defiance. "My client believed she was creating something new," Hayes argued. "She never intended to violate the court's order. Any similarities are coincidental or stem from common industry practices." But Judge Ramirez was unmoved. She cited precedent after precedent establishing that intent is not required to prove civil contempt, only that the order was clear and that the defendant failed to comply. The TRO was unambiguous, she stated. It prohibited any commercial or promotional activity tied to the Preserve Collective concept. The creation of Hearth and Vine, with its near-identical branding, product lines, and target audience, was a transparent end-run around that order. Then came the moment that would dominate headlines for days. Judge Ramirez held Blake Lively in contempt of court. The penalty was severe. In addition to imposing a $250,000 fine, payable immediately, Judge Ramirez ordered Lively to cease all activities related to both Preserve Collective and Hearth and Vine permanently. She also mandated that Lively undergo a court-supervised ethics compliance course and barred her from launching any new lifestyle brand for a period of 3 years without prior judicial approval. Most strikingly, the judge referred the matter to the U.S. Attorney's Office for potential criminal contempt charges, noting that the alleged conspiracy to deceive the court could constitute obstruction of justice. As the gavel fell, Lively remained seated, her face pale but composed. She did not speak to reporters as she exited the courthouse, shielded by a phalanx of security. But the image of her, once the epitome of golden hour glamour, being escorted away under the shadow of legal sanction became an instant cultural flashpoint. Public reaction was swift and polarized. On social media, #BlakeLivelyContempt trended globally within hours. Some fans expressed disbelief, insisting she was being unfairly targeted. "She's just a mom trying to build something meaningful," one supporter tweeted. "Why is everyone so quick to crucify her?" Others, however, saw the case as a long overdue reckoning with celebrity entitlement. "Rich people think rules don't apply to them," read a viral post with over 200,000 likes. Glad the judge didn't let her get away with it. More damning still was evidence that Lively had instructed her team to scrub certain digital assets from Lumina's original work, altering color palettes, swapping fonts, and rewording taglines, just enough to claim they were new creations. In one particularly incriminating email chain, Lively reportedly wrote, "If we change the shade of sage by 5% and call it Forest Whisper, it's ours." Mara can't prove anything. Prosecutors argued this demonstrated not just bad faith, but a deliberate attempt to flout the court's authority. The situation reached its boiling point during a scheduled deposition in late October 2023. Ellison's attorney, Daniel Cho, presented metadata analysis showing that a series of Instagram stories posted by a lifestyle blogger with 800,000 followers, featuring handmade ceramics, organic linens, and artisanal candles under the Hearth and Vine banner, had been coordinated through an IP address linked to Lively's home Wi-Fi network. When confronted with this evidence during cross-examination, Lively invoked her Fifth Amendment right against self-incrimination, a move that Judge Ramirez noted with visible displeasure. "She's not above the law," the judge remarked off the record, according to a court reporter present. Fame doesn't grant immunity from judicial orders. The final act of this legal drama unfolded on November 15, 2023, during a contempt hearing held in a packed Los Angeles courtroom. Dozens of journalists, legal analysts, and curious onlookers filled the gallery, many expecting a dramatic showdown. What they witnessed was less a Hollywood spectacle and more a sobering lesson in the limits of power and privilege. Judge Ramirez opened the proceedings by reiterating the terms of the TRO and the gravity of violating a federal court order. She then turned to Lively, who sat at the defense table in a tailored navy suit, her expression unreadable but her posture tense. "Ms. Lively," the judge began, "you were explicitly instructed not to engage in any activity related to the disputed brand. Yet the evidence before this court suggests you not only continued development under a different name, but actively conspired to conceal your involvement. Do you deny this?"